Today I'll talk about what is a trademark and when is it okay to put that little TM symbol on your logo or your symbol or your business name. We're also going to take a little look at what's the difference between a trademark and a registered trademark, what makes it registered. We're going to see how that differs from copyrights and patents. We're going to find out a little bit about those three things. Also, I have a gardening tip for you that just may save your life if you survive the zombie apocalypse. All that coming up right now on Andy in the Wild.
Hey, you could be larger than life, bigger than the world, living out the hopes and dreams of every boy and every girl. You could fly higher than the sky, shine brighter than the stars. You could have all you ever wanted, shoot the moon and reach for Mars. You know you could.
All right, here we go. So, like I said, we're going to be talking about trademarks, copyrights, and even a little bit about patents. Before I do that, let me say, I am not a lawyer. I am not giving you legal advice. Obviously, I'm not a lawyer. If I was, this show would be called something else. So like, Andy in the Law. Andy in Law. Andy in Law. It would be called that. It's not. It's called Andy in the Wild. So this isn't legal advice. I'm not a lawyer. But I want you to understand a little bit about copyrights, trademarks, patents, so that you have enough information to go do your own research and figure out what you need to do for your own business. Not legal advice. Nope. Okay. Ridiculous legal disclaimer out of the way. Let's take a look at copyrights first. So a copyright protects original works from being copied. Hey, look at that. It's right there in the name. It covers original works like books and movies and music and software and blog posts and podcasts. Poetry, even architecture is covered by a copyright. That's pretty cool. I think it's pretty cool. What it does not cover. A copyright is not going to cover the name or the title of your business or that nifty slogan that you came up with for your business. Those are not protected by a copyright. This is actually where a trademark would step in and be applicable, but we will get to that in a moment. I'll get there. Common words and knowledge are also not something that can be copyrighted, or you're not protected by copyright because of with it when you use a common word or knowledge. So the phrase water is wet or the sky is blue, those by themselves wouldn't be. Now, if you use those in a larger work, yes, the larger work is protected, but those by themselves, common words, phrases, no, not protected. Facts, ideas, systems, and methods of operation. All right, so what does that mean? A math formula won't be protected by a copyright. Also notable, and I find this interesting, fashion is not protected by copyright. This is very surprising to me. It falls under something called useful articles, and I didn't know this ahead of time before I did some research for this episode. There were things I already knew, especially about trademarks, but useful articles. So if you come up with a killer design for some awesome hiking pants, well, nope, not protected by copyright. If you do use a custom pattern on a dress, for example, or let's say you do a t-shirt with a custom design that you've created that's printed on the t-shirt, that is covered by copyright. The design itself, the printing, that part's covered, or the pattern that you use. It's just the design of the clothing itself that is not protected by a copyright. I found that pretty interesting. So if you wanted to get protection on a clothing article, there is a way you could have that happen with a patent, but we'll get to that also. I'll tell you a little bit about that exception. Let's see, what's next? Okay, copyrights only protect tangible forms of expression. This is interesting. So what does that mean? It means that it doesn't protect just your idea by itself. You need to record that idea somewhere, and then the words themselves, once they're recorded, are protected. However, another person can still use your ideas. They just can't use them in the exact form you used the ideas. They can use that idea in another form. So the idea isn't protected, but the work itself, the written work or the video or whatever, is protected. All right. So this leads into something kind of interesting with copyrights, because because an idea itself is not protected and it has to be recorded in some way, it turns out that also choreography or an artistic performance is not protected by copyright. That also surprised me. A place where this actually falls over into a really interesting area is that a live impromptu speech is also not protected by copyright. But here's the thing. You can't just do a flash mob and have it protected by copyright, but you can record the flash mob and then it would be protected by copyright. Or there's other ways you can notate the live event or whatever, and that would also protect it because it was recorded somehow. But I mean, really, who does a flash mob and doesn't get it videoed or something? I mean, that would count. It's recorded on video. So the way this covers speeches also is kind of particular. It means you couldn't have pre-written the speech. You couldn't have videotaped it either, or audio recorded it. The speech itself would have had to have been something that you gave on the spot, impromptu, live, without ever having recorded it as a written form or taken a video of it or audio recorded it at the time you did it. The weird area where that actually brought up something that's really interesting to me, even more interesting to me than what was interesting before, is this goes into an area of where there was a problem in the music industry with people selling bootlegged recordings of concerts and things like that. Because the artists weren't protected in their live performances, anybody could just go to a concert and record it and then sell the bootlegged materials. They've come up with exceptions now where this is covered by other laws. It's illegal now to either record and or sell a bootleg version of a live concert. But in the interim, before that rule came about, the way they got around this was they just recorded every live concert, which is probably why there is a live album for every Dave Matthews Band concert ever. So that's kind of how they got around it. They would just make sure every live performance that an artist gave was recorded, and then somebody else who recorded it and tried to either sell it or give it away even could get in trouble because copyright protected. All right. Something else you should know about copyrights is that if you want to, you can register a copyright with the Library of Congress and make it official. You don't have to. It's not required. You still have a copyright just by publishing or writing down or recording something that is your original work. And the last thing is that a copyright lasts for the life of the author plus 50 years. So that's how long you got one. So even after you're gone, 50 years, you still got protection. It's actually a pretty long time. All right. So we got copyrights. Now we're going to look at trademarks. So this is where it applies to businesses. A trademark is a word, phrase, or symbol that represents your product or your business. So it applies to, among other, maybe a few other things, a business name, a product name, a logo, a symbol, a design. You can actually even get a trademark on a sound that represents your business. I'm thinking boom, 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 something like that, right? It's got to be. Common law trademarks. This is a US only thing. The way it works is that the trademark goes to the first person or business to use a specific brand to sell or market something. So once you claim a name, so you pick out a name that you're going to use for your business and nobody else is already using this name or this product name, and you start doing business under that name or selling a product under that name once it's in the marketplace, now you have, under the common law trademark rule, you have the trademark on that. That's awesome. You don't have to do anything. It just is yours. So this applies even if it's not registered, just by using the name and doing business under it, provided someone else isn't already, you get the protection. It's sort of like copyright in that way, where you don't have to do anything to have it. It just protects you because the rule exists. Common law trademarks, they last pretty much as long as you use them. There is a exception though, where if you don't protect the trademark, you could lose it. This just means if you see someone else using your name for your business or your product, especially if I think it's exceptional, I think it requires that they be in the same industry as you. So I don't exactly know how that works, but I'm going to cover that a little bit more in a second here. But if you see someone else using your name or the same name for a product, and you're selling the same type of product, you're required to ask them to stop using that name. you have to enforce your trademark. If you don't, you could lose it. Now, the question everybody has, and I get asked this quite often, when I do logo designs for someone, I always put the little TM symbol on there for them. Because once you start doing business under a name, or you sell a product under a name that is specific to your product, you are claiming that trademark. Put that little TM on there. Stake your claim. That's what you're doing. Just by using it, you're already getting trademark protection under U.S. common law trademark protection. So why not go ahead and tell everybody, yeah, I'm saying this one's mine. So yes, do it. Put it on there. Stake your claim. It's the wild, wild west, baby. First person to get there and to stake it claims it. Now, registered trademarks. The best way I can describe this is it's like putting a ring on it. You made it official. It is also like registering your copyright. It's also not required to register your trademark. It is more complicated and harder. It's not nearly as easy as registering a copyright. To be granted a registered trademark, you have to have gained a certain amount of recognition. This is exactly how they state it. I don't know what that means exactly, because that sounds extremely subjective to me. So I don't understand how they interpret whether or not it's gained a certain amount of recognition. In what way? I don't know the answer to that, but if you ever decide to register your trademark, you're going to have to find out. I bet they have all kinds of things to figure that out. A registration for a trademark lasts 10 years, and they can be renewed. And just like anything that the government controls, to be granted a trademark registration, you have to fill out a bunch of paperwork and pay a whole bunch more fees. Yeah, super fun. I love working with the governments. So besides just having to go through all the extra effort to get a registration, you also have to deal with all the weird requirements that come with dealing with a government agency. Things like you have to file an affidavit for use of the trademark between the 5th and 6th year of the first 10 years that your trademark is registered. And then you have to pay another fee with that. And then there's another one where you have to file an affidavit again the year before the 10-year anniversary of your first registration. And if you miss either of these, then you lose your registration. Also, you can pay an additional fee just in case you happen to miss one of those and get a 6-month grace period to refile it. Yes, it's awesome. All right, so that's trademarks and registering them. The last one on the list that we had was patents. I'm not going to cover this as much. They're much more complicated and involved. They're also very expensive usually, and there's a lot of requirements to get one. Patents basically cover products and processes. And I guess some examples of that would be a manufacturing process, or remember those hiking pants we talked about? If you have a really cool idea for hiking pants, you can get a patent on those. There's a stipulation though, there's a requirement, and I'll get to it in a second. They can't just be like a cool design. Oh, and then let's say you crossbreed a plant where you've got a guava and a mango, and you crossbreed those to create guangos. You can patent that. Awesome, right? And now I want a guango. Here's a few important notes, though, about patents. A patent can't be obvious. So you will not get it. You're not supposed to be able to get a patent on something if it's something that's obvious. Now, my question in response to this is, obvious to whom? Obvious to whom? Because when I see patent trolls out there suing companies because they have a patent on the process, now I'm not talking about the functionality of like how the things work, but the process of pushing keys on a keyboard to cause data to appear on a monitor for a computer. Yeah, they have a patent. There's someone out there who has a patent on this, and they go around and sue businesses because other businesses are pushing keys on a keyboard to enter data for it to appear on a monitor. That's super obvious. They're not talking about how the keyboard works or the functionality of it or the keys going up and down or the transmission through the cables and through the processors and whatever else to make the data appear. Just the process of I push key on board number appear on screen. Yeah. So patent trolls are out there suing for that. Or there's another one I know of where someone has a patent on the process of images on a website appearing on the screen and then changing, which is every website slider, slideshow, animated image almost ever on any website. So obvious to whom, right? I don't understand these things. All right, the next requirement for a patent that I'm not going to cover much more here. We're almost done. It's got to be a new idea, actually, and it has to actually do something. This is where we come in on those pants we were talking about. The pants, you can't get a patent on your awesome hiking pants unless they do something other than go on your body. So it would have to be that you created some hiking pants that have a really cool way to, I don't know, help you maybe tie a hammock to a tree. I have no idea, but they have to do something. So that actually brings me to things you cannot patent. You can't patent discoveries, medical procedures, scientific theories, or just the way something looks, which I was just trying to cover a second ago. What that does is that leads us to, there's something called a design patent, that if you just want to patent the aesthetics of something, you can get a design patent. Most people don't bother because they sometimes are considered a waste of time since it's very easy to get around them. So there you go. That's it. That's how. That's what I'm going to tell you about patents, at least. So, in conclusion to that, I will just say, let's do a quick review. We just learned about trademarks, copyrights, and patents. So, copyrights protect your original work and creative works. Trademarks protect your brand, and patents protect things that do stuff. So there you have it. I felt good. I know this is a very dry, boring topic. I appreciate you sticking it out with me on this one. But I've always found the trademark thing pretty interesting. Copyright stuff's useful for anybody who does any kind of publishing online. And patents, come on, who doesn't want to be an inventor? But now we have a little bit of basis for these things. And if you didn't understand them fully, now you got at least a general idea of where to go from to find out more about what you want to do. So to follow that up, I would like to reiterate that I am not a lawyer and I am not giving you legal advice because this show is not called, what did I say it was? Andy in Law. This show is not called Andy in Law. Andy in the Law. I don't know. That would be a tough one to figure out for sure how I wanted to do that one. If I ever get my law degree, I'll confront it then. All right. Having said that, again, I'm going to tell you something that you will want to know. I hope you'll want to know this. If you are an entrepreneur, you may already know it. It's not a secret, but you need to be careful about not infringing on another company's trademark. Usually, this is as simple as doing a quick search to see if anybody else is already doing business or selling a product with the name you want to use. And if you don't find it, there's also things with when you apply for a business name in your state, and they a lot of states, they do this thing where they check to see if somebody else is already doing business under that name, and that already gets you a certain step process, a certain number of steps along the process and along the way to knowing that nobody else is using that if you get granted that business name to do business in your state. Now, having said all of that, here's what I'm going to tell you. Usually, even though it's this simple, there are things you have to watch out for. There's stuff I don't even understand about how some of this works. So it also can be different across different industries. Here's one thing I heard about. So the color magenta was used by T-Mobile, and they got a trademark on the color. The color. They trademarked the color. Now, only in the telecommunications industry, as I understand it, but if you were doing business in the telecommunications industry, which is a pretty big industry, it's like phones, internet, I mean, it goes on. You couldn't use the color magenta specifically for your logo or your name or your symbol. That's how I understood it. Now, if you were, I don't know, selling pistachios, right? You have a pistachio company, so that's what, agriculture? Sure, do a magenta pistachio for your symbol. You're probably fine there. But when you hear about things like that, it starts to make you think, okay, so what do I not know that's going to cause me to get in trouble? I'll come back to this at the very end, but generally you're going to be all right. Now, I'm not saying that you should go because it's in a different industry and name something like the Pepsi Motor Company. Don't do that, obviously. You want to be careful about that kind of thing. But it can get ridiculous what some companies will do when they have a trademark in order to enforce it. Remember we said earlier that if you don't protect your trademark, that you can lose it? Well, protecting your trademark is required. Being a complete jerk is optional. If you're not familiar with where I'm going with this, there is a certain magazine for entrepreneurs that got known for being very quick to sue anyone using the word entrepreneur in their name. Now, that's what I call being a jerk. I've only read a little bit about it. I know that it's happened. I've heard about it before. I know of people who have changed their names because of things like that. I also know of when WordPress started enforcing their trademark, a whole bunch of companies that had WordPress in their domain name had to change the name of their website. So the site can still be called whatever they were calling it as long as the word WordPress wasn't part of their business name. But if the URL was like WordPress tips, they had to change it to WP, WordPress, WP tips. This happened and it was a big deal because a whole bunch of people had to come up with a whole bunch of new names. That's why you don't see anyone except WordPress using the name WordPress. All the businesses that are related to it or sell products with it that you want to use that name, they use WP. Now, personally, WordPress is fine. I'm not talking about that here. Personally, I'm not a fan of being able to register extremely common words or get a registered trademark for a word that is incredibly common. And I'll give you some examples like Windows or Apple and entrepreneur. I think it is dumb for them to grant to allow registration of a trademark for a commonly used word like that. But they do, apparently. So that's just a little rant I had. But as long as we're on the subject, I think entrepreneur is not such a great word to begin with. And I'm putting forward the challenge that we should come up with a better word, an entirely new word for people who start businesses. The requirements are it should be something that's shorter, easier to say, and easier to spell than entrepreneur. If you want, post your suggestions or send them to me on Twitter at AndyInTheWild. And if we come up with a better word, I'll spread it out there. Until then, I'm going to use, I say business owner. But also, don't send me any of those little things like solopreneur or any of that nonsense. We're not doing that. That's just as bad, maybe worse, probably worse. All right. Okay. So I finished up. That's everything about the copyrights, the trademarks, the patents. We're done. Now I get to tell you about my really cool tip because it's spring and I get to tell you about a gardening tip that just may save your life if you survive the zombie apocalypse. Good and dramatic there, right? All right. So this one came to me from my neighbor who saw me outside spraying my weeds this last week. And he said, there's this way you can make your own weed killer with vinegar. And I was like, yeah, okay. I mean, I believe vinegar will kill a plant, or at least, getting vinegar on a plant is probably not good for it. So I will start by saying I haven't tried this yet. I did read several articles about it, and best I can tell, results are a little bit mixed. It kind of works, at least for everyone, but I'm not sure everyone gets the results they're expecting. And the reason I do suggest this, or at least I'm telling you about it, is because if you're someone who doesn't like using poison around your home or your family or your pets, well, this is an alternative. Why not give it a try, right? Here's the basic idea. You're going to use vinegar to kill the weed. You're going to mix it with a little bit of dish soap in order to make the vinegar stick on the plant, the leaves of the plant better. It just sort of breaks the surface tension of the vinegar in order to make it spread over it and not just bead off and roll. And then if you want long-term results, you add salt. Here's my warning about salt. For anyone who doesn't already know this, salt in sufficient quantities will kill pretty much anything and keep it from growing back in that area for a very long time. Too much salt in an area can also spread and kill other things that are nearby. There's my warning. Now I'm talking about a lot of salt here, but at least that's I wanted to make sure you knew that in case you didn't know. The things that adding salt would be good for are driveways and patios and places you want at least a season's worth of protection from anything growing back. And it would be bad for lawns and flower beds, or pretty much anywhere you want something to continue to grow. There you go. So salt is good for killing, well, both of these things are good for killing anything. Salt is good for keeping it from growing back. Here is the formula. You're going to get a gallon of white vinegar, and you're going to put in a tablespoon of liquid dish soap. Liquid soap. It doesn't matter. It breaks the surface tension if it's soap. They say dish soap. And if you want to go scorched earth option, you add 1 cup of rock salt or something cheap. Some cheap salt. Table salt's more expensive, so they say get cheap salt. My guess, having not done this, is that the vinegar is probably going to kill whatever you spray it on, the plants, the weeds, the grass. It's going to kill, the leaves and everything. It's going to die and turn brown. And then in a couple of weeks, it's probably going to grow back. Because I don't think the vinegar is not going to kill the roots. That's where products like Roundup come in. That's why they always use the advertising where they say, like, kill the root, kill the weed, and that kind of thing. Because anything else that you spray it on there, it's pretty much just killing the vegetation that's above the surface that you're seeing. So anything that's even slightly hardy is going to probably survive this. But if you are very conscious of what you put out there, if you don't want to worry about, did I contaminate groundwater, or is this going to hurt my pets or my children, why not try it out? You might have to use it every couple of weeks to go back over and kill things again, but it's worth a try. It's certainly the safest weed killer I've ever heard of. So there you have it. And that's everything I had for you in this one. In the next show, I have no idea what I'm going to talk about. I haven't figured it out yet. I am about to leave for a trip to Texas to go to my grandmother's 90th birthday. How exciting is that? So while I'm gone, I'll be thinking about the next episode. I don't know what it's going to be about, but you can guarantee you it's going to be pretty awesome. So come back and check it out. Also, let me just once again say, please don't forget to rate and like and follow and click the notification bell if you're watching this on YouTube. That way you know every time a new episode goes up. You can find me on Twitter and Facebook at Andy in the Wild, or on my website, andyinthewild.com. Send me your suggestions, or tell me if I got something wrong in this episode, because I am talking about an area that, there's a lot of stuff that I'm not an expert on, and I'm trying to give you the information that I know. But if I mess something up, let me know and I'll correct it. Don't forget to leave your comments below if you see a comment area where you're watching this or listening to this. And one more thing, get on those 5-star reviews on iTunes, people. I am waiting. I don't have enough yet. I need more of those 5 stars. Come on, bring them in. Side note, only 5-star reviews are accepted. Oh, sorry. That's the rules. What can I do? Okay, well, thanks for hanging out. I'm Andy Wilkerson, and this is Andy in the Wild.